Thank you, Mr. Speaker. Would the sponsor yield, please?
Will you yield, Mr. Wright?
Quick ones.
Yes, indeed.
Thank you. Now, Mr. Wright, I've got my defense attorney cap on now. All right? Now I'm thinking this is any proceeding is what I'm reading in the statute. I have it here on my fancy new iPad. And that includes proceedings where an indictment is rendered, right?
Any proceeding before a grand jury.
Is there any vehicle by which a stay could be sought from the judge? So if a judge determines, in this example, the judge determines that no one would be necessarily endangered and the information or testimony is going to be released and the DA disagrees, is there any vehicle in which they can stop that information from being released?
A stay on, you keep saying testimony, you and Mr. Graff keep saying testimony. We're talking about charges to the grand jury. Charges to the grand jury.
Let me read
and
it.
I guess a stay or injunction could be sought by counsel.
You know,
or a writ of mandamus.
Sure, I see where we're looking here. I get it now, but I think what's confusing about the language is that it also includes a provision regarding safety and names of witnesses. They're never in the charges. I've conducted probably
they're never released.
1,000 grand juries.
We're talking about instructions to
Right.
the grand jury. We're not talking about releasing testimony. We're not talking about releasing the names or identities of witnesses. We're talking about charges or instructions to the grand jury. Nothing to do with testimony.
Good. I just want to be clear on that because at lines 17 8 through 19, that the court shall make the legal instructions and charges submitted to such grand jury available to the public on request. 19, line 19, provided that the names of witnesses and any information that would identify such witnesses included in such instructions or charges shall be redacted when the court determines. So I guess it is somewhat narrow in that regard, but is there any provision prohibiting the release of those charges prior to the adjudication of the case if, in fact, there is a true bill and an indictment rendered?
Judge's discretion, I do believe.
So in the event multiple
charges... And the instructions come at the end of the proceeding.
I'm sorry?
If I'm not mistaken, the instructions come at the end of the proceeding of the grand jury.
Oh, that's correct. I mean the ultimate trial of the action. And this is what my concern is. What I'm getting at is this. In the event, when I started...
Grand jury finishes before the trial.
I'm sorry?
Grand jury takes place before a trial.
Exactly. And that's my concern. And I guess I can just comment on the bill, if I may, Mr. Speaker.
On the bill.
On the bill, Mr. Palumbo.
Thank you. This wrinkle is an important one because typically the prior administrative proceeding information or there are some admissibility concerns. However, in the court of public opinion or in public in general, in the event multiple charges are submitted to a grand jury and they indict on a handful and no bill a bunch of them, no true bill, so they dismiss a handful of them. If those submitted charges are made public now and the defense attorney has that in his or her hand, the wrinkle is it may impair the ultimate prosecution of that police officer. That when I have now, I said my defense attorney hat on, there's a concern because now the general public in a highly publicized case, as almost all of them are, will somehow get wind because it's now public and released to the public that a handful of charges were already submitted to a grand jury, which is a very low level of proof required, 12 of 23, and they only indicted on a handful. He must be not guilty. And as a defense attorney who would throw that out, that is a serious impairment, if you will, on the prosecution. So now the district attorney, who has sustained and presented in the circumstances, as many of us discussed in the previous bill, that are so rare, now they've got a huge impediment to deal with as a result of a bill which is completely counterintuitive to what I believe the intent of this bill is. So that being said, this is not a good idea. Unfortunately, I think this is going to have the opposite effect. And as such, I urge my colleagues to vote no, and I will be voting no myself. Thank you.